Hello, brother.
Morning, Mr. White.
Hello, Your Honor.
How's jail? Shh. How's jail? Good. The worse a jail visit is, the higher likelihood you have of actually considering when the judge tells you to do something that you will actually do it, right? You, my friend, have been on the lam for 24 years.
Sir.
20. I don't think we've ever had someone with that kind of just.
No, this is a record.
I don't want the record. I don't want it. But this was also unusual because they had a misidentification of an FBI number. So he's 2 for 2.
But he's got to know at some point you can't just continue to run. That, you know, the long arm of the law is at some point.
Yes.
It's it, right?
Absolutely. But as I said, Your Honor, he's here. He's got his family here. His son is here. He has 4 kids and he's working. And I've told him that he must go to Wisconsin and they're going to hire an attorney up there. I bet you a dime to a dollar.
Why haven't they hired a lawyer already?
I have an attorney.
That question, and to try to figure out.
Well, I mean, Your Honor, I don't know, you remember practicing law.
Sure.
So sometimes they just put their head in the sand.
And I guess at that point, the counsel is to be proactive because you know that. So Dave, what do you think?
Well,
I have a hard time giving someone a bond that's been on the land for 24 years. I'm going to say that now. I really do, Mike. As much as I love you and appreciate you and your tenacity.
Yes, sir, and I'm going to be tenacious because 24 years, he was here 4 years ago. They took him into custody.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. This case is already raising eyebrows. 24 years on the run, a defendant finally standing before the judge, and a courtroom weighing one critical question. Can someone who's avoided the law for decades suddenly be trusted to follow it now? You've got arguments about family, stability, and second chances, but also a judge clearly focused on accountability. And just when you think it's straightforward, unexpected twists start to surface. Stick around, because the tension is only building from here.
On the terroristic threat, a misdemeanor, and it's done. I mean, and I understand he's still here. And so I hear what you're saying. I just know that if you're taking care of your kids, if you're living in the same place for a period of time, I think that he's going to take care of his business. The purpose of bail is to ensure his appearance in court and to secure his appearance up there. If we leave him in jail here, and that's the alternative.
Well, it's not leaving him. It's just we are now going to ensure that Wisconsin gets their man.
No,
because
we're ensuring that he's available for Wisconsin to get him. We don't know if Wisconsin's going to come.
they're going to
Say it again.
They confirmed the warrant flag. They're intending on coming unless they change their mind in the last 24 hours. I mean,
Right.
The DA's office does want to judge.
Yeah, I mean, everybody says that.
I can't imagine after 24 years, they're going to say, you know what, just forget it.
Well, I can't imagine prosecuting a delinquency of a child.
Well, one of the cases is a robbery.
Yeah, but we don't know the extent of it. It's not aggravated.
That's
Right? We don't
that's
know.
not what we fight here.
No, I understand. I just think he should be entitled to a bond. He's going to take care of his business. He goes and takes care of it now. You give him 2 weeks.
I promise,
Mike.
Judge.
I'm sorry?
Promise.
Yeah, you promised before
When he was
when you were
18.
17. And then, you know, the thing is Mr. White, don't try to throw other people under the bus. That's not cool. It's all on you. And for you to try to blame it on anyone else is just disingenuous, man. The case, it's 24 years. You've had 365 days for over 24 years. You've had that in the little back of your mind thinking, God, you know, out of sight, out of mind doesn't work with the law.
I've actually hired an attorney prior to this in Milwaukee, Wisconsin. he was working on a bill with the district attorney's office there. Okay, I hired him. He's been hired under $5,000. I paid him to contact, to work a deal with district attorney's office, and told me he was working a deal with them.
What's his name?
Hold on. Is my son here?
Yeah.
He knows, no, he knows his name. I have his number.
It's irrelevant. Doesn't matter. The name just, what matters is action. You know, you telling me something is going to go in there, go out that ear, because I know that you've done this before and you've never followed up. I can't in good conscience give you a loan, man. It's 24 years.
My son, I have a 2-year-old son. He's going to Texas Children's. He has a genetic disorder. Yeah, I can't leave here.
This is where the judge draws a hard line, and it's rooted in a key legal principle: credibility. In bail decisions, the court isn't just looking at your current situation, but your history of compliance. 24 years on the run doesn't just disappear because you show up today. Notice how the judge calls out deflection and refuses to accept blame shifting. That's critical in court. Owning your actions can influence outcomes, but avoiding responsibility almost always works against you. Now, here's a question for you. If someone avoided the law for decades, but now claims they've changed, should the court take that risk or prioritize public trust in the system?
Because his life depends on it. He has a rare genetic mutation. His name is Mariano.
Jones?
He has a rare genetic mutation, and his condition is life or death. I've sought the best doctors in the country for him. I came here for him to treat my baby. His name is Mariano. His doctor is, hold on, Gary Clark, neurologist at Texas Children's.
That's ironic. Gary Clark is my running buddy for 30 years. He'll be back from San Diego next week.
And I know Gary Clark.
I understand, and the good thing that you have,
It's just for the baby, sir. I don't care about myself.
thankfully, that you have a loving sister and you have a loving son that are willing to help you out, so that baby's not getting thrown under the bus. But I'm not going to allow you to sit here and use your baby as a means of trying to get a bond when you've been on the land for 24 years. I'm just not going to do it.
I'm just telling you a story.
Yeah, may it please the court?
Sure.
Based on what I see, how the tea leaves look like they're rolling, maybe we come back here in 15 days. Because I don't think he's going to sign. He may sign the waiver.
Oh, he's going to refuse?
Well,
I mean, if so, let us know now so we can get the governor's warrant, because the thing is then there's going to be another 90 days.
no, I understand that.
You
I'd
know?
like to have a short period of time to talk to him about whether he
Sure.
wants to waive.
Of course, he hasn't waived yet.
No, he's refused.
Okay,
Okay.
you got to understand that.
We carry him till tomorrow. Okay.
I mean, there's no, but
I mean, I know, I can tell the family now, the judge is not going to set the bond. You have two options.
I love you, Mike. I really do. But 24 years, that's unreasonable.
It's pretty impressive.
For me to be able to just, it's,
No, I got it. We'll see you tomorrow.
okay.
It's a pleasure. Well, see you tomorrow. Bye-bye. All right. You have to go again?
What is the one thing I ordered you not to do? And why are you here? So one of two things is evident. Either you don't care about bond conditions, you don't care what judges say, or you have a problem. But, we ordered you not to use. It's a serious case. It's a DWI second offense, and you're using.
Your Honor, I don't blame myself, but I know after we left court.
How is it possibly your fault?
Well, Your Honor, it's because typically what I do with my clients, I emphasize to them the bond conditions and I reiterate how important they are to follow them.
I emphasized on her ad nauseum when she was here last time.
I sincerely,
Stephen, sorry?
I apologize. I know.
If you kill someone on the side of the road, do you think that apology does anything? If I had one strand of hair for every single person that told me sorry in here, holy moly, I would look like Gene Simmons. But no, bond conditions are in there for a reason, right? And when you fail to live up to them, there's one thing that happens. She goes with you. Some talk with me back. Alex, I'm now putting a monitor on your ankle so I know that you're not using an anytime at all times. You will now get a scram device on one ankle so I know that you're not using on your other ankle. I'm going to put a GPS monitor and I'm now giving you a curfew. You are not allowed to be out in the middle of the night. Do you understand? And if you ever test positive again, your bond will be so high that it's going to reach the clouds. Do you understand? You will be taking the Dodge Patas everywhere. No more driving as well. Do you understand?
I can't go to work.
I didn't say you couldn't go to work. You're on a very serious second DWI and you're continuing to consume. I want to do everything in my power to protect the public. I don't want you on the street and I don't want you out in the middle of the night. You're continuing to use. It scares me. Do you know every single day someone dies from an alcohol-related collision in this county? Every single day. And I will do everything in my power to prevent it from happening. I'm modifying your conditions now in lieu of taking you into custody. You can sure do it the other way around. You know, Joaquin.
Yes, sir.
We can always reapproach with conditions at a later time. But I want to
Yes,
know that my Houston is protected because that's the only thing that matters to me. Do you understand?
Yes, sir.
There
Yes,
are
sir.
other ways and you need to be able to find it. But I can't trust you in the car if you're continuing to use when we ask you not to use. I will give you a curfew of 10 p.m. to 6 in the morning. You're not allowed to be out past 10 p.m. If you violate curfew, if you consume alcohol again, then I will lock you up and I'm not going to play this game with you again. Do you understand? Okay. All right, just take a seat for me. We'll be back with you here shortly.
What we just witnessed is a powerful example of how courts balance compassion with accountability. In the first case, the judge made it clear that a 24-year history of avoiding the law outweighs last-minute promises and emotional appeals, even when family is involved. In the second case, the focus shifts to public safety, where violating bond conditions, especially in a DWI case, triggers immediate and strict consequences designed to prevent harm. These rulings highlight a core principle. The justice system isn't just about second chances. It's about trust, responsibility, and protecting the public. Now, we want to hear from you. Do you think the judge made the right call in both situations, or should there have been more leniency? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.